evening. Thank you very much for joining us here on Urban Debate on Mirror Now. I am Heena Gambhir. At 8 p.m. tonight, we are talking about an issue that grabbed national headlines at the beginning of this year. The country was divided over whether or not children should be allowed to practice their faith inside classrooms. The dispute began when a government-run school in Karnataka's Udupi barred girl students from entering classrooms wearing hijab. This triggered a series of protests by Muslim students across the state of Karnataka, who said that they were being deprived of their fundamental right to religion. Soon, there were counter-protests by some other students who came out wearing saffron shawls. The color of religion began to divide young children, and that was disturbing, who should actually have been focusing on getting back to schools after studying at home for over 600 days due to the pandemic. The matter snowballed into a religion versus education issue, and many started asking, what's more important? This matter reached the High Court, and after much deliberation, the Karnataka High Court bench decided to rule in favor of the ban. The court viewers answered three key questions. Question number one: is wearing a headscarf an essential practice of Islam? The court said wearing hijab is not an essential religious practice in Islam. Question number two: is prescription of school uniform violative of one's right? The court said every fundamental right is subject to reasonable restrictions, and a uniform is a reasonable restriction that students must conform to. And third, does Karnataka government's order give uniform compulsory for all students violate Article 14 and 15, to which the court said the order was not unconstitutional. Now, viewers, another troubling observation that the court made was that this was a non-issue before 2004, when dress codes were followed, and the matter was blown out of proportion by certain unseen hands to engineer social unrest. The court has now ordered a speedy and effective investigation into this particular matter. Listen in to the reactions that we got after the order by Karnataka High Court today.
Marks a paradigm shift in interpretation of Article 25 of the Constitution. It restates the position of law as held by the Supreme Court in Shabarimala by saying that what is essentially religious is not sufficient. What is required to be shown is essential to religion. And therefore, whatever be the individual choices, ultimately institutional discipline prevails over individual choice.
I always say women can wear anything, but in an institute where they are going for education and there are some rules, there is a code for the dress, every student must follow. There we should not divide students between religions, and they should follow the dress code.
A lot of things have been clarified and a lot of misgivings have been removed, and I only request all the people to follow it and maintain peace and tranquility in the interest of the children.
The High Court verdict is reiterating what we already know, that hijab is not an essential part of Islam. Not just hijab, even the burqa or the veil is not an essential part of Islam. We all know that it is a patriarchal imposition. However, I consider it's very, very important that girls are educated. The girls should be in school, hijab or no hijab. The girls should be educated, the girls should be empowered, the girls should be able to access higher education, and I think that is of utmost importance here.
Let's now go across to my colleague Revati, who's been tracking the developments very, very closely throughout the day today, and she's joining us live this evening. Revati, good evening. You know, we thought that today's verdict is going to bring clarity on the hijab issue, but now with the petitioners moving Supreme Court, this issue has become even more complicated.
Good evening, Heena. Yes, that's right. The Karnataka High Court's verdict essentially results in maintaining status quo. It has upheld the government order. And for now, the students cannot enter classrooms wearing a hijab as far as this Karnataka High Court order goes. But the students are refusing to give up. They want to take forward this legal battle and are moving to the apex court, where they hope they will get a favorable decision. Now, what has happened as a consequence to this is that even after that interim order by a single judge bench, which said that you cannot enter classrooms wearing hijab, saffron shawls or any other religious symbols, several students have stayed outside classrooms saying that they will not attend classes or examinations if they are not allowed to enter wearing a hijab. And that stands even after this final verdict by the three-judge bench by the from the Karnataka High Court. Now, until they get that response, until they get that favorable verdict, they are saying that they will continue that protest. So while the legal battle continues on one side, there are students here in Karnataka, across Karnataka, in different colleges. It might be just a handful of them, just 4 or 5 of them, or a dozen of them, but they're all missing classes. They are mixing their examination, and thereby most of them, some of them even losing out an entire academic year because of this. So there is that direct conflict of their right to education as well as their right to practice religion, which the Karnataka High Court has said it is not essential. It has also gone on to point out 2 important observations. One is that the High Court has said it is a mere attire, which is why it is not fundamental to Islam. And also the fact that if the court rules that hijab is an essential religious practice, then it means that anybody who is not wearing a hijab, they will by default become a sinner, and Islam religion will itself lose its glory. That is what it will result in, is what the High Court has pointed out. But the petitioners do not want to give up. They are going to go ahead with this legal battle. As far as the law and order situation on the ground is concerned, it has been peaceful so far. Section 144, the prohibitory orders are in place in different parts of the state. Right. But as far as this legal battle goes, that will go on one side, it will go to the apex court, but on the other side, students are definitely losing out on their academics as well.
All right. Thank you very much, Revati, for the moment, for joining us with all of those details. Now, disappointed by the court order, students continue to protest and skip classes. They say wearing a hijab is their constitutional right, and taking it away is equivalent to taking away their soul. Listen in.
ये हमारा राइट है, हम खड़े होंगे, हम लड़ेंगे। जब तक हमें हमारा जस्टिस नहीं मिलेगा, हम छोड़ेंगे ही नहीं। और सवाल ही नहीं पैदा होता कि एजुकेशन बाइकआउट करना ऐसे। हमें कॉन्स्टिट्यूशन ही ने राइट दिया है कि राइट टू रिलीजन एंड राइट टू एजुकेशन। Now how can they tell us you don't have essential right to wear hijab and all?
कॉन्स्टिट्यूशनल राइट सिखाया जा रहा है हमारा, कैसे हम हमारा हक लिए वो सिखाया जा रहा है, हमारा सेल्फ रेस्पेक्ट सिखाया जा रहा है। लेकिन जो भी इन्होंने पढ़ा है और हमें पढ़ाया है, हम यही कर रहे हैं। हम हमारा सिर्फ हक मांग रहे हैं। हमें हमारा हक चाहिए। ये अभी आया है ना, पहले से तो नहीं था। पहले तो सभी भी कंटिन्यू किया है, पढ़ी हिजाब पहनकर किया है, अभी भी हिजाब पहन कर करे। मेरे कजिन तक है, उन्हें एमडी तक किया है, डॉक्टर तक बने हैं। उनको कोई ने किसी ने कुछ नहीं कहा। आप क्यों बोल रहा है? हम करेंगे, अपना एजुकेशन पूरा करेंगे हिजाब पहनकर। इट इज अवर रिलीजियस राइट ऑल्सो। वी आर अपोजिंग they are opposing like we have to remove our scarf. This is our self respect. How we have to remove our scarf? Because this is our self respect. It's like our soul. If they are taking our scarf from our head, they are taking our soul from us.
Similarly, the opposition leaders have also criticized Karnataka High Court banning hijab in schools. Listen in.
ये अपना अपना कोई हिजाब रखे न रखे, ये उससे अपना है। इससे ज़्यादा मैं कुछ कह नहीं। लोग करते हैं। अब कई इस्लामिक कंट्रीज़ में जाइए, वहाँ हिजाब नहीं है। हमारा नेबर जो देखिए वहाँ नहीं है।
I disagree with that judgment of the Honorable High Court because it suspends the fundamental rights relating to expression, religion, culture and conscience. It overlooks what is said in the preamble of our Constitution, liberty of thought, equality and justice. It allows discrimination, which again violates Article 15. And saying that it is not essential. See, what is essentiality is, in my opinion, it is a conscious decision of that individual. I definitely feel that this is a right case to be appealed in the Honorable Supreme Court.
तो मैं समझती हूँ एक तरफ से हम बहुत बड़े दावे करते हैं औरतों के अधिकारों की, उनकी इख्तियारात की कि उनको बाइख्तियार बनाना है, एम्पावरमेंट करना है, और दूसरी तरफ से हम उनको ये भी हक नहीं देते हैं कि वो क्या पहने और क्या ना पहने। और अगर वो अपनी मर्ज़ी के मुताबिक कपड़े पहनती है तो उनको हरासा किया जाता है। सड़कों पे आपने देखा किस तरह गुंडे मवाली उनके पीछे पड़ जाते हैं और सरकारें जो वहाँ की होती हैं वो तमाशाबीन बन जाती हैं। तो मैं समझती हूँ ये बहुत गलत है, ये ऐसा नहीं होना चाहिए। हर इंसान को, हर औरत को, हर बच्ची को ये हक होना चाहिए कि वो क्या कपड़ा पहने और क्या कपड़ा नहीं पहने। ये इसका फैसला अदालतों के पास नहीं होना चाहिए।
We respect the High Court and the court judgments, but here it is not practical whatever they have said. So anyways, we have an opportunity to go to Supreme Court. We will go to Supreme Court because the people are not happy with the decision given. And whether it is an essential practice or not a practice, it has been there with the community, the religion followers have been following it for thousands of years. So suddenly somebody cannot decide it, it is not.
So you heard, viewers, the reactions that we got on the order of Karnataka High Court from the opposition, from the students, from leaders within the BJP. And this evening, we are joined by the Primary and Secondary Education Minister of Karnataka, BC Nagesh. Mr. Nagesh, thank you very much for joining us here on Urban Debate on Mirror Now. Firstly, your first reaction to the order by Karnataka High Court today.
Honorable High Court has upheld the stand taken by the government. Actually, there was a provision in Karnataka Education Act and Rule 95. According to that, uniform was prescribed for the PU students in Karnataka. There was a problem in one college of Udupi. 6 students said that religious is more important than education. They started wearing hijab. When they were objected, they went to the court, and the petitioner asked the court that it is their fundamental right. So no one can force us the uniform on us. SDMC doesn't have any right to prescribe the uniform. Such were the petitioner's demand. But clearly the High Court has given a historic judgment saying whatever the decision taken by the education department is right. And though it is a fundamental right, it is a relative right. So collective rights is more important than the individual right. So I am happy that whoever designed uniform in this country, thinking that the common temperament and common thinking has to arrive among the youngsters of the country, particularly in the education, one should not feel that one is above and one is below. Every child should feel that is the son of the motherland, India. So that has been upheld by the court.
Mr. Nagesh, you say that collective right is more important than individual right, but the Muslim girls today are feeling disheartened with this verdict. What about their freedom of religion?
Yeah, they have every right. It is a democratic nation, so every citizen has its own right to go and approach Supreme Court, and they may do that. But what I sincerely tell the student is that they should not lose their classes, they should not lose their education, which is very important. And as you know that both Prime Minister Mr. Atal Bihari Vajpayee and Modi were very particular. Atalji started Sarva Shikshana Abhiyan to see that every citizen of this country should get education. And Modi ji was still particular that her beti should be taught, and beti padhao and beti bachao. So they should be made to stand on their own legs. So I request the student to come to the classes, attend the classes, should continue their education. So whatever the judgment comes from the Supreme Court, then we can decide how to do it. But now they have to, as a citizen of the country, they should respect the judgment given by the High Court and they should attend. Then also when the High Court gave an interim order, we requested the girls to follow. As a patriotic citizen of this country, one should follow the rule of the land, and we expected them, they may attend the classes. Few did not attend, but at least not even Modi ji is very particular, not even single child should lose classes, so I request them to attend the classes till the judge. If they go to the Supreme Court, they should not lose their education.
But won't this order prompt parents to transfer their children from government schools to private schools or private colleges, which might allow them to wear hijab?
Even if they continue in the private colleges, we are not worried. But we were worried if they leave schools, that's all. Wow, our concern is their education. Our concern is not that they should only study in this particular college.
So this order, for the benefit of our viewers, could you just help us understand this applies to all colleges across Karnataka, government as well as private, or only government schools and colleges?
It definitely applies to all colleges, government institutions, and whoever registered according to the Karnataka Education Act has to follow the verdict of the High Court.
You spoke about Prime Minister's Beti Bachao, Beti Padhao campaign and the efforts that were made to send girls to school. Will this not impact strides made in Muslim women's education?
After Modi ji became Prime Minister, after his stress on child education, number of Muslim students coming to the college had increased, and as you should also know this, out of 86,000 odd PU student sister from that community, only 200 and odd are protesting. All other girls are coming, attending the classes. They are following the rules, whatever they prescribed by the government or the schools. They are very disciplined students. Even these girls, till December, were very good students, very disciplined students. I didn't know how in December they became more religious, and they want religious sentiment is more than the education for them. I don't know what made them to do that. And it is the bad luck, even for the society, and bad luck of that girls, I think so. They have been provoked by few people, are instigated by few people, or as some organizations doesn't want particularly Muslim girls to be educated so that they become independent. They will not hear the voice of few people. So because of that reasons, I think that girls may not be able to take independent decision. If they are allowed to take independent decision, definitely, according to me, they will attend the classes from tomorrow, wearing the uniform as they were wearing and coming to the colleges before December.
Mr. Nagesh, in the past as well, when we spoke to you, you told us that these girls were being influenced by certain people because, before December, of course, things were absolutely fine. The dress code was being followed. Now, your government has got a huge responsibility to ensure that no one is allowed to vitiate the atmosphere in schools and colleges again. How do you plan to address this? What is it that your government is now planning to do so that things remain peaceful on the ground?
Definitely government is not allowing for that. You should be knowing that we are running 77,000 institutions in Karnataka. Karnataka is a very big state. We have more than 1 crore 13 lakh students studying in our education institution. Out of that, only in few places, 4 or 5 places, there were some incident last time when the interim order was we received, and I feel that nothing will happen this time. There will be still their egos are satisfied. There may be some protest, but government is capable of handling it.
All right. Thank you very much, Mr. Nagesh. Thank you for joining us here on Urban Debate on Mirror Now this evening. Let's also welcome Justice S.N. Dhingra, former Judge, Delhi High Court, joining us on Urban Debate as well this evening. Justice Dhingra, thank you very much for taking out time to join us live this evening on Mirror Now. Your first reaction to what happened in Karnataka today, Karnataka High Court upholding ban on hijab in educational institutions, and simultaneously observing that wearing hijab is not an essential religious practice of Islam. And because, you know, it had become a debate between religion and education. Your reaction?
You see, it is effort of the people to bring religion into such things. The duty of the court is to test whether this effort of bringing religion into all this controversy was right or wrong. It stood the constitutional test or not. The court was essentially having the duty to find out whether hijab was an essential religious practice of Muslims or not. The court has adequately answered that, citing all the arguments which were referred, citing the scriptures, and had come to conclusion that hijab was not an essential religious practice of Islam, and it was not an you see effort of the education department to deprive any community from the essential religious practice. So that is how the court found it, and that is how you see the constitution also mandates that while talking of fundamental rights under Article 19 and fundamental right under Article 25, the court has to see whether reasonable restrictions as provided under Article 19 the restrictions were reasonable or not, and whether the dictate or the order violated any of the essential religious practice. So this happened in Sabrimala case also. You see, when this issue of Sabrimala came up before Supreme Court, the Supreme Court laid down the test of essential religious practice, and also laid down the test that it also must satisfy the morality of the Constitution. And the Supreme Court found that in Sabrimala case, by majority judgment, that the practice being followed there did not satisfy the essential religious practice as well as the morality of the Constitution. Similarly, in this case also, Supreme Court has, High Court, Karnataka High Court full bench has come to the conclusion that hijab, as was being, you see, pressed into the service for making that it was an essential religious practice, actually was not essential religious practice.
Okay.
See, if you have heard Muslim scholars, and if you had opportunity to understand Muslim law, see, the hijab is not mentioned as a part of dress even in the Holy Scripture, which are followed by Muslims. Quran does not talk of hijab, it only talk of parda. That also, and which Karnataka High Court has you see, very beautifully laid down as how this parda came into in Middle East when there were several incidents of TVs, eve teasing and all those, and the protection was required to the women and girls, that hijab got introduced. Otherwise, hijab was not part of the essential religious practice. Even in Muslim country like Syria, hijab has been banned from 2007 in school and colleges. Not only Syria, but where many Western countries have banned hijab due to security reasons. And all Muslims have accepted this there, that yes, this is a reasonable restriction, which is for security of the state is required. And in Syria, it has been banned for public order and public morality, that school and colleges must be free from hijab. So this is how the hijab has
Justice
been
Dhingra,
international. Yes.
Okay, but Justice Dhingra, we know that Constitution simultaneously gives right to religion. Now, that is what these girls have today also spoken about. Is this right absolute? And I also want to understand from you, is the insistence to wear uniform a violation of constitutional tenets, of religion?
See, I think this was made clear at the time when Constitution was adopted. The religion has several practices which are given in the name of religion. Even the Dahej dowry was also given name of religion. Sati Pratha was given name of religion. And in Islam, the triple talaq was given name of religion. So these, you see, the community can take shelter of religion for any of its vices or practices. The court has to go into the facts and into the religious practices much before when this practice was started by this, when the religion itself was instituted. And fortunately, in case of Muslim law, see, it is only 17 or 1800 year old, and entire literature of religion is available. So it was not difficult for anyone to find out whether this practice is essential religious practice or not. The religion is something different. Essential religious practice is something different. You may, in the name of religion, do anything at your home. Nobody will say that what you are doing at your home. But if you are in public and you want something to be there in protected, your practice be protected in public as religion, then you have to pass the essential test, the constitutional test, that this practice which you are saying is religion, whether it is essential part of your religion or not. You see, in name of Sati Pratha, the women were being put into fires.
Yes.
And this was given name of religion.
Absolutely.
And now, see, women, girls are being provocated to boycott classes in the name of hijab. So it is anti-women. The whole thing, you see, has been racked up. It is against the women's right of education. And the community must think that what they are doing, they are preventing and a practice which is not even essential. You are going to market, wear hijab, you are going to anywhere, wear burqa. Who is stopping you? Yes.
But Justice Dhingra, when the court says that hijab is not intrinsic to Islam, is this issue open for further judicial scrutiny? Because this matter, of course, is now going to be in Supreme Court as well.
So long as we have, you see, provision of judicial review by higher court, these matters are always open for scrutiny. Even from high court decision, you can file an appeal before Supreme Court. They say you are right, because it is constitutional matter, so it will be definitely taken to Supreme Court. I think it has already been taken to Supreme Court. So there it will be again heard by Supreme Court judges, and they also will arrive at a conclusion which according to them is appropriate according to the constitutional interpretation of different rights of Indian citizens. So this judicial review is available.
And last question. Okay, last question, Justice Dhingra, before we let you go. It's being said that Sikh boys wear turban inside the classroom. Does that argument hold water?
Not at all. You see, although the turban is not an, I consider, is not an essential part of the Sikh religion also, because there the Sikh religion has prescribed 5 kakars, Kacha, Kanga, Kesh, Katar, Kripan, and these are 5 kakars. Now the wearing of turban is not because of religion, but because of the essential requirement of covering their head, their long hair, to protect them from damage and to protect them from getting dirty every day. You see, Sikhs cannot wash. It takes a lot of time to wash hair, get ready, after get them dried and this. So they wear pagdi. And most of you must have noticed in schools and you see when they are children, they don't wear pagdi. In schools, most of them wear patka, which is a cloth which they wear tied up on their hair so that their hair don't get damaged or don't get dirty so easily, so that they have not to wash it every day. So that is how this was allowed, so that they can maintain hygiene and can also take care of the hair. It has not been allowed as part of essential religious practice, but as a part of practical solution to their keeping hair as directed by their religion.
All right. Justice Dhingra, thank you very much for joining us here on Urban Debate on Mirror Now this evening and helping us understand this very, very important issue, because it had become a debate between religion and education. Now, Karnataka High Court, of course, has given its verdict, but the matter is now also going to be heard in the Supreme Court. Thank you, Justice Dhingra, for joining us on Urban Debate.